I believe it. I've been told that the most repeated command in the Bible is do not be afraid. And I don't sense any fear here tonight. But because we're not afraid, we're going to talk about some things that people of the world might be afraid of. And one of those things is death. But as followers of Christ and believers in the Almighty, we don't fear death. We don't think of it in the same way that the world does. And so I'm going to talk a little bit about what we can do to plan for death. And I'm going to be very basic in this talk. But of course, if you have some questions after I'm done that are more specific, feel free. So, in planning for death, we all have heard of last wills and testaments. And these are not new. In fact, in Hebrews chapter 9, starting verse 15, it says, "And for this cause he is the mediator of the New Testament, that by means of death for the redemption of the transgressions that were under the first testament, they which are called might receive the promise of eternal inheritance. For where a testament is, there must also of necessity be the death of the testator. For a testament is of force after men are dead. Otherwise, it is of no strength at all while the testator liveth." That's the way it is in Oklahoma today. A will does not take effect until the person who made it has passed away. So, some terms that maybe you've heard before. Testate. That means you die with a will. You have a will. Intestate means that you have passed away without a will. And your belongings and your things will be distributed to heirs based off of the laws of the state of Oklahoma. If you have a will, you devise real estate to devasees. You bequeath personal property to legatees. A legatee, do you know where that word comes from? Legacy. We think of the word legacy, we think about, I like sports. So I think of the legacy of, it's basketball season, so we'll go with Michael Jordan. People talk about his legacy, right? Well, that's kind of it's a new way to use the term, but that's not the original meaning of the term. A legacy just meant your stuff, your personal stuff, the clothes you're wearing, the jewelry you wear, the microwave, the dishwasher, whatever. That was a legacy. So it's kind of been changed over the years to mean something different. So the types of wills. You can write your own will. And I appreciate what you said, Brian. I'm not here for new clients, okay? I'm not here to try to get business. I'm here to just give you information. And so I'm going to prove it to you. Because I'm going to tell you how to get your own will without needing a silly attorney. You can have a holographic will. A holographic will is one that is written entirely in the hand of the testator. Okay, let me back up. We need some more terms. A testator is a man. A testatrix is a woman. That is the female version of that word. So, if you're taking notes, and I apologize, I don't have a PowerPoint tonight, but if you're taking notes, that's a new word. A lot of times that's a new word to people, testatrix. Where was I? Holographic will, that's right. So it's written in the hand of the testator or the testatrix, and it's dated and signed. You can also have a non-cupative will, N-U-N-C-U-P-A-T-I-V-E, non-cupative. What's that? Yeah. It is a spoken will. but normally it's spoken at the time near the death of the individual. So it's not very reliable, and it has to be done in front of witnesses. And then those witnesses have to go into court and testify that they heard the individual say, whatever they said. So that's not there's Title 84 of the Oklahoma Statutes, Section 51, specifically provides for a non-cupative will. But I don't advise a non-cupative will because, you just never know if you're going to be able to speak when the good Lord calls you to your home.
Yes, sir.
Holographic will is perfectly acceptable. You can write it on legal pad. You can write it on a napkin. As long as you sign it and date it and you have testamentary intent, it's good. So let's talk about testamentary intent. And I'll give you an example. I'm going to give you two examples. So this is an example of a will I did last month. And it starts out by saying, I'll just use Brian's name. How about that? That I, Brian Fuller, now a resident of citizen of Washington County, state of Oklahoma, being of sound and disposing mind and memory, and fully capable of making this will and thoroughly understanding its nature and effect, but realizing the uncertainty of life and desiring to make disposition of my property and affairs while in full health and strength, do make, publish, and declare this my last will and testament, and I hereby revoke and cancel any other wills or codicils to wills or other testamentary instruments by me heretofore at any time made. So the testamentary intent is, well, he's doing this because he knows that he's going to die at some point. Yeah. So that's why he states it, knowing the uncertainty of life. Now, this is a little shorter, and this is the will of a guy named Cater King. And my mom was a king. So this is my great-great-grandfather's will. And check out how he starts his will off. In the name of God, amen. That's what it says. I, Cater King of the state of North Carolina and the county of Bertie, being in sound mind and memory, thanks be to the Almighty God for the same, do make and ordain this my last will and testament to wit, and I won't go through all of it. But he has testamentary intent here, even back in 1806. So even then, that was still a requirement. But I like the way he said it better than the first one, don't you?
Yes, amen.
And if you want one like that, it's still be just as good as the first one I read. So you have to have testamentary intent. You have to have testamentary capacity. You have to know, well, I'll just read my notes, okay? You must be able to comprehend generally the nature and extent of property which constitutes your estate, which you intend to dispose of, and to recollect the natural objects of your bounty. Okay? Now, what does that mean? I'll give you an example. Had a guy come in several years ago, and I didn't know if he was right. I didn't know if he was, able to understand what I was talking to him about. And so I got to talk to him, and he started listing all these things that he had that he wanted to go to his children. Well, I found out that all these things he listed, he really didn't own. He thought he owned them, but he didn't. And all the children that he listed, he made them up. They didn't exist. He was imagining them. And so he did not have testamentary capacity. Now, testamentary capacity is not the same as determining if someone has the lack of capacity to where you could get a guardianship over them. Testamentary capacity, all you have to do is be able to know what you have and that the person or people you're giving it to would make sense. Your natural bounty, it would be your kids or a good friend or another relative. So if you had property and you had that right, but you wanted to give it to, I'm sticking with sports, Patrick Mahomes, who you've never met, that's the quarterback for Kansas City Chiefs. He doesn't need anything, by the way. That would not cover the testamentary capacity because you've never met the guy, and he doesn't need it. So that's testamentary capacity. So we talked about holographic wills and non-cupative wills. A written will, like the one I just read, the one that you would, if you went to an attorney and had them do it, it must be witnessed by at least two people. And those two people that witness your will cannot be beneficiaries of the will. And they can't be someone who might be considered to have some kind of influence over you. So if, for instance, in our office, we never have spouses be witnesses to the other spouse's will or anything like that, or kids to be witnesses of their mom and dad's will, or even vice versa. So it just needs to be someone, a third party, that can say, yes, this person told me this is his or her last will and testament. Another thing that Oklahoma provides is a self-proving will. So you have your two witnesses. You can attach to the end of the will an affidavit that's signed by the testator or testatrix and the two witnesses that says, on this date, we heard this person say this is my last will and testament. And it's notarized. And then if you have a self-proving will, when your will has to be probated, there is no need for the witnesses to come in and testify before the court to get the will admitted into probate. If you don't have a self-proving will, the two witnesses that witnessed your will have to come to court and testify that they witnessed you sign your will. So to avoid that step, they've passed a statute that allows self-proving wills, and it saves a lot of time. Okay, so I'm going to move on to trusts, because a lot of people hear about trusts and wonder what exactly do they do and why do people have them. They're good. They are a replacement for a will. They are a very good way to deal with your property. They have advantages, and they don't have a whole lot of disadvantages other than the upfront cost, for one, is more than just a will. But a trust is a document that survives your death. And it basically creates an entity, kind of like a corporation, that survives your death or your spouse's death, or both you and your spouse. And then you have a successor trustee that complies with or carries out the instructions that are contained in the trust, the testamentary element of the trust. I want my children to have these things. I want my sister to have this. You know, that you can have at that part, the trust and the will look very similar in the testamentary part of it. Most trusts are revocable. That means that you can get rid of them. You can cancel them. You can throw them away. You can rip them up and say this trust doesn't exist anymore. You've heard of maybe inter vivos trusts. Anybody heard that term? That is a trust that you obviously make during your lifetime. But you can also have a testamentary trust, which is a trust that's created in your will. And I'll give you an example of how that happens. So I have a lot of people that come to me that are young people with children. And to you folks that I see out here that have young children, one of the most important things of a will is to nominate a guardian for your child, instead of the state picking who your child's guardian is going to be in the event that both you and your spouse pass away. So a lot of wills that we do for young couples will have in the will, we create a trust. Because if the child is under 18, when we don't want a child, well, most of us don't, we don't want an 18-year-old child to receive a large lump sum of money when they turn 18. No offense to anybody in here that's 18 or younger, but I have a degree in biology, and your frontal lobe of your brain isn't fully developed yet, and sometimes you don't make great decisions. So we decide, and I'm not kidding about the biology thing, I do have a degree in biology. So we try to avoid young people being put in a position where they just all of a sudden receive a large amount of cash. So in the will, we create a trust that takes effect and is created at the death of the mother or the father, if both of them have passed. And that trust has a trustee, and that any life insurance proceeds or things like that will be put into that trust, and the trustee is ordered or required to maintain the child and use that money for the benefit of the child, the health, education, and training of that child. So you can plan for death. And as I mentioned before, we're not afraid of that. You can plan for incapacity as well. You can have a power of attorney, more specifically, a durable power of attorney. Durable in that it survives your incapacity. Every state in the Union has statutes that allow for durable powers of attorney. In a power of attorney, you name your attorney in fact. That is someone you trust that if you are incapacitated will handle your property in the same way you would if you were able to. You can also have limited powers of attorney. Did one for a couple that was traveling out of country, but they were trying to sell a piece of property, and it was going to close when they wanted to be out, and they'd planned for this trip for a long time, so they didn't want. So they had an associate of mine, named him as limited, had a limited power of attorney. Their attorney in fact only for that transaction, and that's how we defined it for the sale of that piece of real property. And most limited powers of attorney are also limited and durable power of attorney. So it would, if there was an accident or something, or they were both hospitalized in London, England, then that person would still be able to act as their attorney in fact, because it would survive their incapacity. What we usually deal with is it's what is called a general and durable power of attorney. General in that it lists several powers that your attorney in fact would have in the event you're incapacitated. All the way from dealing with your property to being able to get your medical records. We have to put special language in these days because of HIPAA. You guys are familiar with HIPAA? I'm familiar with it, but I don't know what all the letters stand for. Health something. I know the H stands for health. It's a federal act that basically protects your medical records and documents from being seen by anybody you don't want them to see them. So that is good to have. Now, another document that we recommend in planning for either death or incapacity is a living will, health care directive. And this is a document that was created back in the 90s. And I was actually in law school at the time that a lot of states were passing laws to create living wills and healthcare directives. And what happened in 2 states, there was a young lady in Missouri that had been involved in a terrible car accident, and she was brain dead. And her family wanted to remove her from life support, and the doctors would not let them. And she was on life support for, I believe, over 20 years. And there was a similar situation, and I think it was Florida. Very similar situation, young woman, car accident. And same situation, that she was on life support for several years because she did not have a document. The doctors at that time said, we have taken an oath where we cannot pull that plug. It's against our, I think they call it a Hippocratic oath, right? So states started passing laws that said, okay, if you, while you are living, you give instructions that say, if I'm in this condition, I don't want to be on life support, then that'll be okay. And Oklahoma passed a law, and then I'm probably telling you more than you want to know, but I've got time, I think. The state of Oklahoma passed a law, and the Oklahoma Attorney General said, this is not constitutional, so you need to change it. And so the state of Oklahoma did. I believe that was around early 2000s that occurred. And so now, obviously the form that we use now is not one that we prepare. It is a statutory form. You can go online and you can print it off yourself. And you can, it's got to be witnessed by 2 people. But you can go and print that document off yourself. You don't need one of those silly attorneys again, right? You can do it yourself. They are they're very good, and I advise them. And so, a little more explanation on these living wills is in advanced directives. There are 3 particular situations these documents deal with, and I'm going to try to remember them off the top of my head. One's persistently unconscious. The other one is end of stage condition. And the third one is terminal illness. I asked a doctor one time the difference between the end of stage condition and terminal illness, and she told me, but I don't remember what she said because I really don't see that much of a difference, between those 2 situations. But apparently, medically, there is enough of a difference to where the doctor said you need to have this in there that we're advising on the writing of the statute. So you have those 3 situations, and in each situation, you get to choose, and you got to initial out beside your choice. I don't want anything. I don't want you to do anything. If I'm persistently unconscious, don't do anything. The second option is, I don't want you to put me on a machine that's going to make me breathe and pump my heart, but I want you, if I'm able, I want you to give me water and give me food. And then the third option is do everything. I want to be on a machine, and I want you to feed me and give me water. So those are your 3 options you pick for each of the 3 conditions. Also in that document is you get to choose your health care proxy. So if you're incapacitated and you cannot tell the doctor what you want to do, you can choose your health care proxy, usually your spouse or a close relative or a child. And the health care proxy can make decisions, but they cannot override the decisions you made in those 3 situations we were just talking about. That is not, they cannot do anything about that. So, we talked about planning for death and planning for incapacity. Now, these things, by doing this, you're helping your family, right? you are making it easier for them to carry out your wishes after you're gone or if you're incapacitated. Family is, it's important to make things easier for your family.
Yes, sir.
And as part of my practice, it's one of the nice things about it is when we do these estate plans, whether it's just a will or a trust and a will and powers of attorney and all that, it's very satisfying to see someone who has lost a spouse and is grieving not have to worry about these decisions, and that it's all taken care of. Now, I mentioned family, so let's talk about family a little bit, and Brian already alluded to it. In my practice, I do family law, in addition to estate planning and litigation, but family law of divorce, paternity, guardianship, adoptions, and the adoptions are the fun ones. But divorce is not fun. It is, sometimes, like Brian said, I'm not going to preach, all right? But I think there is some scenarios where a divorce is going to happen. And I'm going to let you handle, when those situations are. But sometimes it's just unavoidable. And what I try to do is I always tell my clients, we're going to take the high road, no matter what. We're not going to get in the tit for tat and all that, because that happens. But I can tell you that, and maybe some of you have experienced it, it's very costly, not only financially, but emotionally, and not only for the person who's going through it, but for their family, their parents, and their children, specifically the children. And it is to be avoided if at all possible. Sometimes it's, like I said, sometimes it's not, but if at all possible, it is to be avoided. I make a habit of inquiring when first meeting with clients, have you gone to counseling? Have you gone to marital counseling? Whether it's with your pastor, your minister, a professional counselor who has letters out by their name, any of that. Have you done any of that? Second, I ask, is reconciliation a possibility? And if they've answered no to the first one and they answer yes to the second one, then I say, well, you got to make the first one a yes, or as much as possible, right? Sometimes they don't have a choice, but the other party may not be on the same page. But I've had a lot of people who have come in. If you get that discussion going, I've had several people reconcile. I've had people get divorced and then remarry because they continued the discussion. So it's not too late. I had a couple. So once again, I'm probably telling you more. I don't know what am I good? Okay. So I had a couple. So I can represent one person in a divorce. I can't represent both of them ethically. I cannot represent both the husband and wife. I can represent one of them, and if the other one doesn't want to hire an attorney, I can discuss the documents with him or her, but I cannot give them legal advice unless my client says, yeah, it's okay. But I had a couple, I represented the wife, and it was very amicable. They were very friendly and had children and said they wanted a divorce, and they just weren't getting along. And I went through the whole counseling, and and we tried it. And so they showed up on the day that we were supposed to go get the decree entered in their marriage, to dissolve their marriage. And they show up together, and they're holding hands. And they're sitting out on the couch waiting to see me, and they're both crying. And so I go out, have them come in, sign the document, make the copies, and I said, let's go on over to the courthouse. And we're walking over, and our office is right next door to the Truity Federal Credit Union building. And I can remember standing on the corner, getting ready to cross the street at the Truity Credit Union building to go to the courthouse. And they're holding hands and crying, and I turned to them and I said, are you guys sure that you want to do this? Do you want to dissolve your marriage? And they look at each other and, well, we think we better. And so I said, well, I don't really believe you. I mean, because you guys are getting along pretty good, and I'm concerned that if we go and get you divorced and then you guys go home, you're not married anymore, so you better keep separated, because then you'd have other problems. And, well, they went ahead and got divorced, but they got remarried like a month later. So that was a happy ending. That was a happy ending. I had, this kind of combines estate planning and marriage. I had a client who was a over-the-road truck driver, and he was one of my favorite clients. And he looked like a big Kenny Rogers, just all the gray hair and the full gray beard, and he was a big guy. And he had a significant other, and he came in to do estate planning. And it's amazing how good money those guys make. And so we're going through the documents, and his significant other is there with him. She's a nice lady. And he was saying, well, I want to do this, and I want to do this, and I want to do this. And I said, I can't use his name. I'll use another name. I said, Brian, I said, you are treating her like you're married to her. Just marry her. And they were sitting there, and they looked at each other. They said, okay. They walked across the street to the courthouse and got married. So I felt good about that. But, another thing, this may be a little preaching, but I also do paternity cases. And that's where a child is born out of wedlock, right? And it's a lot of times it's just messy. And I think if people would follow the teaching that we're given in the New Testament, a lot of the problems we talk about, we hear about on the news, we wouldn't have those problems if people would get married, stay married, and raise their children together. Now, I don't want to say, I know it happens, and sometimes it's not avoidable, but I think that is the plan. I think Paul's model in Ephesians 5, husband is head of the house, Christ is head of the church. And I think that model is not cultural. It's God ordained, right? So I'm glad you guys are agreeing with me. Thanks, I feel better. And I'm just saying that to say, and I'm just to reiterate, I just don't think we'd have a lot of the problems we see in our communities if people followed that.
Yes, sir.
Now, that doesn't mean that, and I think you guys, Brian was telling me, I'm really impressed by the mission that you guys have here, the ministry that you have, and just because people have gone through those situations doesn't mean that they can't join us, right? Now, I'm ready for some questions, and I'll give answers as much as possible. But hold on, I got to start my clock. Is that what we're going to do? Oh, okay. No. Did you?
Real question. Explain to us common law marriage, what that looks like in legal terms, and how you see that from spiritual terms.
Okay. Common law marriage is two people who have the intent to be married, and they hold themselves out to others as a married couple. A good example is if a couple, Mr. Smith and Miss Taylor, are living together, but they say, this is for life, we're going to be married, and Miss Taylor starts calling herself Miss Smith, and they file a joint tax return, and they tell the IRS we're husband and wife, then they have the intent to be married. They are common law married, and there is no such thing as a common law divorce. Once you are common law married, it's just like you have a certificate from the courthouse, and if that marriage is going to be dissolved, you have to go to court to dissolve it. There is no length of time. You can be in the same abode and never have the intent to be married for 20 years or longer and never be common law married. It is all about intent and holding out to other people that you are married. A ring. We are married. If she starts using his last name, they change the name on their checks to George Smith and Jennifer Smith or whatever.
So how does that look, Mr. Brown, as far as, so when does the courthouse or the state of Oklahoma, when do they see that? Is it tax filing, or is it, what triggers that if they have to get a divorce?
Well, there's really no document or anything like that that says, okay, now you're married. Now you could go get one. You could go get a certificate of common law marriage from the courthouse if you want to. But really what triggers it is usually when they stop getting along and one leaves or whatever, and they start talking about, okay, who's getting this property? And then one says, well, we're common law married, so I'm going to go hire an attorney and I get the house, or something like that. So that's usually where it comes up. And you have to, in that case, you'd have to produce evidence of the common law marriage. And the easiest thing is a tax return where they told the IRS that they are married filing jointly. Mm-hmm. Any other questions? Yes, sir.
Is there such a thing as like a temporary will? Like, per se, you go out of the country with your wife, your spouse, you create a will, you come back and it's default.
You can, at any time, you can revoke any will. So yes, in that case, all wills are good until you decide you don't want it, and so you could do that.
Is there a financial fee for what you just mentioned?
For a temporary will, well, if you use an attorney, probably, but if you did a holographic will, no. Because if they're going on a trip, he could write on a legal pad and say, we're going on this trip and I'm uncertain about whether I'm going to make it back, so I want so-and-so to have you know, this, and I want Brian's church to have all my money, and so on and so forth, then, you know, he could do that. And you just sign it and date it. It's important that you date it on the holographic will. You've got to date it. Does anybody, I'm sorry, go ahead.
I was wondering, so I've heard of people having like conditions on wills, like somebody owes a ranch something that if their kid lives in New York or something, they have to come to work the ranch for a year or something before they actually take over the property. And is that a thing or is that?
Mm-hmm. Yeah, yeah. You can have conditional wills, and there are some conditions that courts aren't going to abide by necessarily. But yeah, you can have certain conditions put in your will. I remember one when I was looking through my notes. All these notes here are from law school, and I was making my notes, and I thought, wait a minute, I've got all my notes still, so I'll just look at these. But there's one in here, I'm not going to take time to file it, but there was one about, in a will, the guy said, my son will get this if he stops smoking. So, that was interesting. What I was going to say on the question about the holographic will, that any John Wayne fans in here? All right, all right. The number one Western ever made is The Searchers. I'm not asking that, I'm saying that. That is a statement of fact. The number one Western ever made is The Searchers with John Wayne. And in that movie, you know that, he's been injured. And he's sitting down and he's written out a will. And the guy that's with him, Martin Polly, that's the character's name, he's reading the will. And he gets upset with him because he says he doesn't have any living kin when they're there trying to rescue his niece. And so Martin Polly gets mad at him. But that was a holographic will, just so you know. That's right. Okay, any other? Yes?
If the attorney in fact responsible for someone else, are they responsible for the client's financial debts?
Good question. No. A attorney in fact cannot be responsible for the person who made the durable power of attorney for their debts. Now, if it's determined that there's been a breach of the fiduciary duty of the attorney in fact, then they can be responsible for any damages for that, but they can't be responsible for debts of the person. So if my parents who live here in Bartlesville, if they have made me their attorney in fact, and they become incapacitated and they're in the hospital and they have a large hospital bill, I cannot be liable for that hospital bill. It will have to come out of their estate.
What's the difference between a child durable power of attorney and an adult durable power of attorney? Is it the same?
Well, when you say child durable power of attorney, what are you?
If something happens to the mom and she's incapacitated, it goes to somebody else that makes decisions.
Okay. So no, there's not any difference based on what I think you're talking about. You can have a durable power of attorney that allows an attorney in fact to care for your children. There's a specific statute that was created for a power of attorney for custody. And that's a good question. I'm glad you brought that up. And that, once again, is a statutory form. You can go online and print that off. Those powers of attorney only last a year, and you can revoke them at any time. But they are sometimes good for If someone is a single parent is in the military and is sent overseas or what, they can sign one of these attorneys or powers of attorney to give their parents or someone authority to have custody of their child. They can go enroll them in school. They can take them to the doctor and things like that. So those are very helpful. Good question. Thank you for bringing that up. Yes?
Someone online is asking if you would explain what an irrevocable trust is.
Okay. An irrevocable trust is a trust that once you sign it and create the trust and fund the trust, that you cannot get rid of it. It is there for the duration. And whatever assets are in it are in it. Irrevocable trusts are usually used and were used back when the estate tax, the federal estate tax, was relatively low. And a lot of people would create irrevocable life insurance trusts, have a life insurance policy in the irrevocable trust, pay the premium every year, and since it's irrevocable trust, it's considered a gift to the beneficiaries. And each of the beneficiaries would get they call them a crummy notice, I think, that they would have to sign and say, yeah, we acknowledge that we want that money to go and pay the premium for the life insurance trust. And then if the person died with an estate that was large enough to incur a federal estate tax, the proceeds from that insurance policy would be used to pay that tax. And then whatever's left over would be given to the beneficiaries. The federal estate tax is quite high right now as far as how much you would have to have in your estate to owe federal estate tax. And I should have looked that up before I came here tonight, but I didn't. But it's in the millions. I think it's over 10 million that you can give to anybody you want without incurring any kind of estate tax. So it used to be, when I was in law school, I think it was at 750,000. Any assets you had that exceeded the value of 750,000, you paid federal estate tax. Oklahoma no longer has an estate tax, so that's good. Yes, sir. No, just you, and as I mentioned, if the important thing is you date it, and it's all in your own handwriting. You can't type some of it and handwrite other. It's all got to be in your own handwriting, signed and dated. Yes.
Do you see a lot of people when like they come in, they want to do wills and live in them? Do you see a lot of them not wanting to do advance directives or anything like that? Thought of that, or are they open to it?
Most people are open to it, and most of the time I tell them it's not, absolutely necessary, but advisable. Some people kind of get squeamish about it, but
I am for that. It's very good.
right.
You never know.
Mm-hmm.
I've experienced with my own loved one in the hospital, and them asking if you have that, and I'm like, no, and then they're asking if you want, us to do CPR and all that stuff, and in my mind I'm thinking, it doesn't matter what she says, because
Mm.
the minute that she goes unconscious and she doesn't have anything, I can override that.
Mm.
So I want them to see that, the benefit of having the big things that they see and the family can override it.
Yeah, that makes me think of DNRs. They're a completely different deal from what we've been talking about, and I haven't done a lot of those. I had one lady that wanted a DNR, so And that was 10 years ago. And for some reason, I remember who she was and her name, and that was 10 years ago, and I don't know why. And I can't remember what I ate last night, but I can remember that. It doesn't make any sense. Yes, ma'am.
Do you recommend that your bank account be put in a trust?
Yes, ma'am. Yes, ma'am. When we create a trust, we advise our clients to put everything they can into the trust, especially real property, because the main purpose of a probate is to clear title to real property. And one of the advantages of a trust is you avoid probate. If you have all your real property in the trust survives your death, and the trustee just, when it's sold, signs a trustee's deed and conveys the property to the new owner. So it is very important if you have a trust to make sure real property's in it. Bank accounts as well. You can put bank accounts into a trust, but you just make the ownership change. You don't have to change the name on your checks. Well, most banks don't make you change names on checks. You just need to make sure that the ownership is the, Thomas J. Brown and Manya D. Brown Revocable Trust. Yes.
All I have, my bank account is in a trust. My husband passed away 3 years ago, so now mine is the only one that can write checks on my account.
Mm-hmm.
And I wanted my daughter to be able to do it. We went to the bank and asked if they have a form or something that she could
Mm-hmm.
be able to write checks if I get, I can't take care of things.
Mm-hmm.
And they said only if you write a new trust.
Hmm. Hmm. Well, you can. There's ways you can fix it, and
She is designated as my executor.
mhm.
So when I get unconscious or die, she will be able to take care of all I have.
Mhm.
But I thought maybe it might be good to have it on my bank account,
Mhm.
take care of checks that I forgot to do.
Mhm. So you bring up another term that we didn't talk about is executor, which is someone who is named in a will to basically run the probate, to be appointed by the court to take care of the probate action. If you're intestate and you don't have a will, and it's called an administrator. So those are a couple more terms that we hadn't talked about yet. Good. That yes. You have a trust and a will? Yes, that is good. And just so you know, and you guys are learning more terms here tonight, the will is usually called a pour-over will, because if you have a trust, your will is going to say, if I have anything that's not already in my trust, I give it to my trust. And so you're pouring everything over into the trust. So the law school guys came up with this clever name of pour-over will. So I just thought I'd pass it along. Yes, ma'am.
So if something were to happen to you and your husband has kids and stuff, and you have it in your will one way, like the kids go to one set of grandparents, is there anything that the other grandparents is there any way they could fight that and get their kids, or is it like set?
A nomination of guardian by a parent is pretty ironclad. There could be some situations where someone could contest it, but they would have to prove that the nominated grandparents are basically not fit to be guardians. Okay, any other? Yes, ma'am.
Kind of goes to the rest of the grandparents things. Is there grandparent law or grandparent rights in Oklahoma?
Well, there is a statute that is called the Grandparental Visitation Rights statute. And I'm glad you asked that, because I'm gonna tell you something that's important to know. You parents out there, you have a constitutionally protected right to raise your children as you see fit, both under the Oklahoma Constitution and the United States Constitution. So there was a case that came out of the state of Washington called Granville v. Troxel that created this idea of grandparental visitation rights. And the United States Supreme Court, Justice O'Connor wrote the opinion, I think, basically said that the state is not going to interfere with parents and how they raise their children unless they can prove that the children are going to be harmed. And there's some other things that go along with that, and I just don't recall them off the top of my head, unfortunately. But it was a good decision for parents. But several states have passed laws that would allow a grandparent to go to court and request visitation rights. Oklahoma's law is basically follows the Troxel v. Granville reasoning, and there was a case that came out of the Oklahoma Supreme Court. I can't recall the name of it off the top of my head, but the statute follows those two cases. And basically, in my opinion, in order to get grandparental visitation rights, you almost have to prove a parent unfit. Almost. And I'm thinking, well, if you can do that, why are you not asking for a guardianship? So, any other questions? Yes, sir.
You talked about adoption at one point. What is the time process for adoption?
Okay. Step-parent adoption, or?
Or just like regular?
Okay. That's a good question, and I don't know the answer. Because it is so varied depending on what agency you're using or what the situation is with the foster care, and whether the child is of Native American ancestry, and all those things have a role in determining how long it takes for an adoption to go through. Adoptions, like I said, I don't know, are we good on time? I was going to tell you a war story. Yeah, that doesn't sound good, does it? That's the litigator part of me talking. But I was dealing with this adoption out of Tulsa, and the child was Native American. I'm telling you this to tell you this is one of the toughest days of my practice that I can remember. And the couple that was adopting the child was from Alabama, and they drove to Oklahoma, and before the child was born, and they had to stay in Oklahoma a certain amount of time, and because it was an interstate adoption. And the child was born, and the mother, prior to birth, had been talking with the adoptive parents, and she said, yeah, basically picked them to adopt her child. And so I had filed the petition, and in that situation, I had to go to the hospital, and I was appointed by the court as the one to carry the child out of the hospital and deliver the child to the adoptive parents. Well, when I get there, the mother of the birth mother was there, unexpectedly, by anybody. And she started talking to her daughter, saying, no, you can do this, you can, and the daughter was saying, no. And so I picked the child up, carried the child out, and hand the child to my clients, and we think everything's fine. Child, like I mentioned, the child's Native American, Cherokee. In that situation, they have, I want to say it's 10 days, but I think it may be longer now. that they can basically change their mind, even after the child's been given to the adoptive parents. And they were getting ready to go back to Alabama, and we got the phone call. She's changed her mind and wants the child back. So I had to, in my office, they came up and had the exchange of the child in my office. And I didn't know, that's the kind of situation where you don't know what to say to that young couple that had this child for 6-7 days, and then had to give the child back. It was rough. But they were Christians, and they leaned on God and got through it.
Praise God. Anybody else have any quick questions?
I do on the Native American part, so if my husband and I pass, we assign, say, a Caucasian guardian over our child. Can the tribal court come against that and overrule it if there's a Native American family member that's wanting to get guardianship of the child?
Okay, let me understand this correctly. Your child is of, okay, and you've nominated a guardian? Okay, okay. The adoption's done, and or wait a minute, is this?
If we were to pass away, my husband and I, say we got killed
Okay.
in a car accident, we had signed a white person.
No, I don't think that would happen. I don't think that the tribe would have any kind of standing in a situation like that, where the parents, one of you is a member of the tribe, has nominated this guardian. They're not going to try to interfere with that. They shouldn't. And I know the chief of the Osage tribe. His name's Jeffrey Standingberry. He's an attorney. I've gone head to head against him. He's a good guy. I like Jeff. I mean, Chief Standingberry. I'm sorry. Yes, ma'am.
Mine's kind of a messed up question in a way. So, say the parents are no longer together and they have a child, and if that one parent should pass away, can their parent, that person that passed away, can their parent come in and get some kind of grandparent visitation like he had before he passed away?
They could try, but there's several criteria they would have to meet in order to file that petition for grandparental visitation rights. They'd have to have an established relationship and prove detriment to the child if the visitation didn't occur. And I mean, it'd be difficult. Grandparental visitation rights, in order to get them with a parent contesting it, it's very difficult. It can happen, but it's difficult.
Okay, so say you do get that right, would you have to pay that person child support?
The grandparent that has visitation rights, no. That they would not have custody of the child. They would just have visitation rights, so they would not be obligated to financially support the child. They would not be legally obligated to financially support the child, but I would hope that they would help in some way.
Anybody else have any quick questions? Are y'all enjoying this? Thank you, Mr. Brown, for all things you taught me.
Well, I want to thank you for inviting me, and it's been a pleasure.